So once again, I am Nigel May, and I'm with the JLRT Privacy Group, and this is a presentation to speak about the Utah Consumer Privacy Act. So let's jump into it. Why privacy? We're also going to talk about key requirements. We'll talk a little bit about solutions at the end, because we want to give you the essential information that you need to take away from this call. So Utah has now become the fourth state to pass legislation. As mentioned at the start of the presentation, it became law as of December 31st, 2023, just in time for the 2024 year. So Utah is at the leading edge of a wave of coming privacy legislation. There are several other states that have tabled legislation and will be passing it within the next year or two. It's also important to note that there are multiple federal statutes. Some of you may be familiar with HIPAA, which covers health information, GLB, or the Gramm-Leach-Bliley Act, which covers financial information and also contains the Fair Credit Reporting Act. And there are literally hundreds more. This is why states have been taking the initiative to pass their own legislation. It gives them both, it makes it both concise, and it also gives them clout. So it puts them in charge of enforcing their own regulations. So the UCP, or Utah Consumer Privacy Act, specifically makes note of the fact that state legislation does not supersede. In fact, it works in accordance with all existing federal regulations. We will touch on that a little bit. So this seems a little overwhelming. There's so much to know and potentially so much to do. So let's start off with looking at why privacy. So the reason we need to care about privacy is because our customers and consumers do. And we also have to keep in mind that this applies to our employees, third parties that we may work with, and partners that we interact with during the course of our business. So privacy is all about protecting an individual's privacy and data rights, and it's not optional. It is the law. So what are we actually talking about? Because we're talking about individuals, we're speaking about and we're referencing personally identifiable information, or as the UCP Act states, personal data. And I've taken this definition directly from the Act. So what is it? It's information that is linked, reasonably linkable, to an identified individual or an identifiable individual. In other words, this is about individual data. It's about your right to have your own personal information that specifically identifies you or me, protected or safeguarded. It can be a single piece or a combination of information, personal information, that collectively identifies someone. Some examples would be a social security number. Now that would specifically identify an individual, and that's an example of a single piece. There's also financial information, health information, educational information. Again, it can be a combination. So maybe there are a few different pieces of information when added together would specifically identify myself. For instance, my address would not specifically identify who I am, since there are multiple people at this at my address. But that coupled with perhaps my name, my age, could specifically identify me. It is worth mentioning that, particularly in the age in which we live, things like biometric information is also considered. For example, I use my fingerprint to unlock my phone. That would be an example of biometric. Closed caption TV. A lot of businesses now are using that for surveillance purposes. That is also considered to be personal information. So again, it can seem a little overwhelming. We are going to simplify that in this presentation. But the key question to ask ourselves as a business is, do we collect or hold PII, or personal data? And the answer to that really is yes. Because if you collect, process, or store personally identifiable information, you are legally obligated to have processes and safeguards in place to protect it. So let's take a step back again and talk about consumers' privacy rights, because you and I have the right to privacy and to have our personal data safeguarded. So what does that allow? With the passing of the UCPA, what does that now allow Utah consumers to do? So they now have an expectation to know what personal data a business collects, uses, shares, and sells. They have a right to know how their data is being used. So what is the purpose of the collection or use or sharing or holding of that data? They have the right to request access to that information. So an individual can come to you and say, what information have you collected about me? They also have the right to request deletion under certain circumstances. So for instance, something like a warranty, proof of sale, those kinds of things, you would not delete the personal information because, again, there is business purpose behind that for holding it. The Act also introduces the requirement for opt-out, for an opt-out option to be made available. That has to be easy to use, easy to find, and non-conditional. So we can't say, all right, you can opt out of the use of your data for transactional or sale purposes, but you have to do this first. We're not allowed to do that. You also have to give the option where people can select to not sell their data. And most importantly, or I guess also as importantly, they have the right to expect transparency. So again, we look at some of the previous items that have been listed here. So requesting access or deletion to their personal data. So we need as a business to be transparent about what we're collecting and what we're doing with it. And they also have the right to expect safeguarding of their personal data, that businesses are at least taking reasonable steps to safeguard that information. The Act also allows enforcement. So it authorizes the Division of Consumer Protection to investigate complaints, enforce the new Act, and potentially impose penalties for violation. So what do we do? This seems a little overwhelming. Well, at the state, federal, or even international level, the purpose of privacy legislation is really all trying to achieve a similar goal, and that is to protect privacy and data rights. So how do we do that? We can take some steps to comply and also to support the business to improve the trust that we generate with consumers. It's very important to note that on average, someone will take 7 to 10 seconds to decide whether or not they are willing to share their information with you. And one of the key ways that we can do that is by having an informative privacy policy. So what a privacy policy does is it allows us to provide that transparency, to clearly state what information we're collecting, why we're collecting it. So it's a way of consolidating the information, providing that transparency, and generating trust that people know what we're doing, why we're doing it, that we actually care about and have safeguarding process and protocols in place to protect their data. It's also important to have a data protection person or designate a responsible person. So this is essential for the Act as well. Again, that needs to be an individual or it can be a designate. So you can appoint someone or even a third party, which is where we could come in to be responsible for compliance. And it is very important to have that individual so that people know who's in charge, that someone is actually taking an active look at what you need to do and be compliant. And also if there are questions, concerns within your own organization, that you have someone identified. If you have not identified somebody, the default is the most senior person in your organization, which makes sense because you really have to have your organization or your business take privacy seriously. And very importantly, a risk assessment. So what is a risk and impact assessment? That is proactively looking at how you collect personal information, your business processes around that, potentially how you use it, what you're using it for, who has access to it. So essentially following the data from the time that it comes into your organization, who has access to it, what it's used for, how and where it gets stored, and also very importantly, how it gets deleted. So that is something that is often overlooked. Um, there is a certain expectation within business that all data is good data. That is not necessarily the case. Again, there is the concept of data minimization. So really based on what we need the information for and what we're going to do with it, we really only have to collect what is essential to meet those business purposes. So having excess data, collecting excess data, keeping it around past its useful life, it clutters up our data. It creates inefficiencies because it can make reporting and analysis more difficult, and it could potentially even create a liability if for some reason that data was to be breached and we have a lot of data that we either shouldn't have or don't need to keep. So a risk assessment allows us to basically follow the data, look at our business processes around that, look at our authorizations around who has access to that, and proactively identify where there is potential risk. This is also very helpful and very useful if there is a breach, because we understand our data environment, we understand where the risks are. So it'll allow us to quickly plug the breach, and it'll also allow us to quickly do an assessment of how much impact that breach has caused. So what records have been affected, what kind of records, how many, those sorts of things. And that's what we can accomplish in a risk assessment. So again, maybe this all seems a little overwhelming. I have not gone into a lot of detail or depth on the subject, but congratulations to you for attending the seminar because you've taken that really critical first step, and that is understanding privacy and data protection basics. Now, again, this presentation has touched on the basics. We would be happy to answer questions. We would be happy to go into more detail. But you have taken that first step to understand what the requirements are for you as a business, and at least understand the idea and the concept of privacy and data protection rights. The next step is to know your risks. Now, there are a variety of different ways to address this. Again, there is the act that is available to read. There's a raft of information available. There are some guidelines that are laid out as well, both at the state and federal level. But I go back to the previous slide and I talk about a risk assessment. So understanding your risks, knowing if your business has vulnerabilities, and being proactive about that so that you can understand if there is a risk, what priority you need to set, what areas you may or may not want to focus on, where you want to dedicate your time, energy, and resources. So again, being better informed. You've taken the first step, and the next step is to better understand your risks. We actually can help there as well. We do provide a report. It is a set of questions that you can go through. It would take about a half an hour to go through those questions if you were to do them on your own. And that will help us understand and generate a report for you to better understand where you stand on your privacy journey. And this all leads to securing your business. So I really have to say that there is no solution that can keep your personally identifiable information or personal data 100% safe. It doesn't matter who you are, where you're located, how big you are, how small you are, what kind of security protocols, business processes you have in place. There is always the possibility of a breach. So as a business, we all need to make a reasonable effort to secure that personal data. We need to make a plan both to deal with the breach and then also proactively to understand what we need to do to be in compliance and remain in compliance. Making someone responsible, that really is key. So that's a very important first step, or primary step, because by having somebody responsible, you can make sure that you're meeting the guidelines, that you're in compliance, and that you maintain compliance. Again, it's also a very useful resource to have internally and externally for answering questions, making changes, and really championing privacy. So the bottom line is we need to manage our personal data within our business processes, within our data and security protocols. It really doesn't make any sense. It's not efficient, and it may not even be achievable if we try to meet privacy and data requirements outside of what we do as a business. So it really is personal information. Personal data is a subset of our business's data. Think about how you would operate your business if customers were not, or consumers were not willing to share their personal information with you. So again, it's an important piece of information that you need to run your business, but it is a piece of information that needs to be managed within your business processes and your data and security protocols. So I will wrap it up by just emphasizing the benefits. So I'm a big believer in the carrot as opposed to the stick. So yes, the new legislation and federal existing legislation do carry potential penalties. But really, at the end of the day, managing personal data is going to make your business more secure. It's going to make it more trustworthy. And again, I remind you, the average person takes 7 to 10 seconds to decide whether or not they want to share their information with you. And one of the primary things that's going to influence their decision is whether or not they trust you. It'll also make you more efficient. So anytime you're doing a better job of managing your data, it is going to help your organization. Anytime that you do a better job of managing your business processes, again, those can all make you more efficient as a business. And that really is the return on investment. So that concludes the introduction. Again, the intent was not to make you an expert, but to identify some things that you need to know and lay out some next steps for what you can and need to do. So this is our question and answer opportunity. Before I jump into the chat room, I do want to address a couple of questions that have come up. We did have conversations with some people who were not able to join. One of the questions was, I have a retail business with customer records on site. If I have a customer familiar with the new law, what will they be most concerned about, and how do I address it? This was not a setup, it is a real question. And it really encapsulates what we've just spoken about. So those next steps, having procedures and protocols in place that allow us as a business to safeguard personal data and allow us to be transparent to our consumers about how we safeguard their data. When people ask me what it is that I do, one of the questions that I like to ask back to them is, how do you feel about your personal information being available to business? How do you feel about your personal information being available online? And it's very easy for us to put ourselves in that consumer or customer role, because that's what we are as well as business people. The other thing that we need to also address to answer this question is to ensure that we have provided the ability to opt out and also select the option to not sell my data. Another question that has come up is, do I need to spend time on this on a regular basis, or is there a way to put a policy in place so my employees know how to deal with privacy concerns that come up? In other words, what can I do to put this on autopilot as much as possible? So this is a fair question, and it's something that we get a lot. As business people, we have a lot of priorities. We have a lot of things pushing for our time and our money. And So how can we put this on autopilot? Well, it does take some proactive upfront work. Again, part of that is the privacy policy, part of that is doing the risk assessment. So I have pretty much covered that on some of the next steps to put some of those policies and protocols in place. It's very, very important to understand that having a privacy policy is a very important document, but it's also very important to understand that we need to actually do what we say that we're going to do. So the other thing that I'll add for this particular question is employees are very important. They're the face of our business. They often are the main or only point of contact with our consumers and prospective customers. So training is important, having resource materials, and again, having a responsible person. So if they do have questions, concerns, if they don't know how to respond to a request, for instance, a request for information, knowing who they can go to. All right, so that pretty much wraps things up. We didn't have any additional questions at this time. So I would like to thank you. Again, I am part of the JWT Privacy Group. You can find us online, we have a website, or if you'd like to contact myself or my colleagues Ian or Sean, again, our email is just our name at JWT Privacy.